Hello, now we are going to talk about Section 3. This section deals mainly with foreign investment law. Continuously improving legislation is indispensable for foreign investment. In order to further expand the opening up of the economy and actively promote foreign investment, PRC Foreign Investment Law was adopted on March 15, 2019. Now, this section will only deal with the foreign investment law. I will introduce the law in 4 parts. Firstly, let's see the concept of several law terms. Now, part 1 is foreign investment. Foreign investment refers to the investment activities of foreign national persons, enterprises, or other organizations, indirectly or directly within the territory of China, including the following. First, foreign investors can set up a foreign enterprise in China alone or jointly with other investors. Secondly, foreign investors can obtain shares, equities, property shares, or other similar rights and interests of enterprises within the territory of China. Thirdly, foreign investors can invest in new projects in China alone or jointly with other investors. Fourthly, other investment prescribed by laws, administrative regulations, or specified by the State Council. So let's talk about foreign investors and foreign funded enterprises. Foreign investors refer to foreign national persons, enterprises, or organizations. It should be noted that foreign investors in the foreign investment law do not include the investors from Hong Kong, Macau, and Taiwan. In terms of name, foreign investment has a broader concept and there is no country restriction. In the future, there should be no legal obstacles to including Hong Kong, Macau, and Taiwan investors into the scope of foreign investment. A foreign-funded enterprise refers to enterprise established in China in accordance with Chinese law and which is a joint investment by foreign investors and Chinese investment or investment only by the foreign investors, including Sino-foreign joint ventures, Sino-foreign cooperative enterprises, and foreign capital. Now, there are 3 types of enterprises. Now, part 2, investment promotion system. To begin with, let's find out the basic framework of the law is. Article 4 on foreign investment law stipulates the state implements a pre-establishment national retreatment plan plus a negative list management system for foreign investment. Pre-establishment national treatment plus negative list is one of the new highly standard international investment rules. For the purpose of preceding paragraph, the pre-establishment of national treatment refers to the granting to foreign investors and their investment in the stage of investment access treatment no less favorable than the granted to domestic investors and their investments. The negative list refers to special administration measures for access to foreign investment in specific fields as stipulated by the state. The state will give national treatment to foreign investment outside the negative list. For foreign investment on the negative list, the review system is implemented and national treatment is not applicable. Now there is a special note. The management system of pre-establishment national treatment plus negative list does not mean the national treatment will not be implemented after admission. The pre-establishment of national treatment plus the negative list management system expands the scope of application of national treatment obligations from after access to before access, rather than denying the continued implementation of national treatment after access. So what are the specific measures to promote foreign investment? First, domestic and foreign enterprise will equally apply various policies. Foreign-funded enterprises shall equally apply the various policies of the state to support the development of enterprises in accordance with the law. To formulate laws, regulations, and rules related to foreign investment, appropriate methods shall be adopted to solicit opinions and suggestions from foreign investment enterprises. According to the international practice, if any country or region adopts discriminatory prohibitions, restrictions, or other similar measures against China in terms of investment, China can take corresponding measures against that country or region based on the actual conditions. Secondly, foreign-funded enterprises will have the right to participate equally in China's standardization work. The state guarantees that foreign-funded enterprises participate in the standard-setting work on an equal basis in accordance with the law, and strengthens information disclosure, and social supervision of standard setting. The mandatory standards formulated by the state are equally applicable to foreign-funded enterprises. Third, foreign-funded enterprises can participate in government procurement fairly. The state guarantees that foreign-funded enterprises participate in government procurement activities through fair competition in accordance with the law. In government procurement, products produced in China by foreign-funded enterprises are totally equally in accordance with the law. Fourth, foreign-funded enterprises can raise funds through the capital market. Foreign-funded enterprises may raise funds through public offerings of stocks, corporate bonds, and other securities and other methods in accordance with the law. Fifth, local investment promotion policies are open to foreign investment. Local people's government at various levels may formulate foreign investment promotion policies with their legal authority. The third part is related to investment protection system. Foreign investments often pay attention to legal protection and operating cost. This section mainly introduces the following regulations. First, no expropriation of foreign capital under special circumstances. The state does not impose expropriation on the investment of foreign investments. Under the special circumstances, the state may expropriate or requisite the investment of foreign investors in accordance with the law for the public interest. Expropriation shall be carried out in accordance with legal procedures, and fair and reasonable compensation shall be given in time. Second, the liberalization of the inward and outward remittance of foreign investment funds. Foreign investors' capital contributions, profits, capital gains, income from asset disposal, intellectual property licensing fee, compensation obtained in accordance with the law, and income from liquidation in China may be freely remitted and remitted in renminbi or foreign exchange in accordance with the law. Third, strengthen the protection of intellectual property right for foreign investors and foreign investment enterprises. The state protects the intellectual property rights of foreign investors and foreign invested enterprises, protects the legitimate rights and interests of intellectual property rights holders and related rights holders. I encourage technical cooperation based on voluntary principles and business rules. The conditions for technical cooperation in the process of foreign investment shall be determined through equal negotiation by all investors in accordance with the principle of fairness. And administrative agencies and their staff shall not use administrative means to force the transfer of technology. Fourth, require legal government to strictly abide by policy commitments and contractual agreements made in accordance with the law. The local people's government at all levels and their relative departments shall fulfill the policy commitment made to foreign investors and foreign invested enterprises in accordance with the law, and various contracts concluded in accordance with the law. If the policy commitment or contractual agreement are changed due to the needs of national interest and social public interest, they shall be carried out in accordance with legal authority and procedures. And the losses suffered by foreign investors and foreign invested enterprises shall be compensated in accordance with the law. Fifth, no derogation of the legal rights and interests of foreign invested enterprises. People's government at all levels and their relative departments shall formulate regulatory documents involving foreign investment and shall comply with the provisions of law and regulations. And where there is no basis for laws or administrative regulations, they shall not detract from the legitimate rights and interests of foreign invested enterprises or increase their obligations, shall not establish market access and exit conditions. It is not allowed to interfere with the normal production and operation activities of foreign invested enterprises. 6. Establish a complaint mechanism for foreign invested enterprises. The state establishes a complaint work mechanism for foreign invested enterprises, coordinates and improves major policies and measures in the complaint framework of foreign invested enterprises, and promptly handles problems reported by foreign invested enterprises or their investors. Foreign invested enterprises or their investors who believe that the administrative actions of administrative agencies and the staff infringe their legitimate rights and interests can apply for settlement through the foreign invested enterprise complaint mechanism. In addition, you can also apply for administrative reconsideration and file an administrative lawsuit in accordance with the law. The part 4, Foreign Investment Management System. The Foreign Investment Management System mainly focuses on the foreign investment access and review system, the most important of which is the negative list. The negative list of foreign investment access emphasizes that all fields, industries, and projects outside the negative list do not acquire administrative approval. Investors can apply to the competent authorities for establishment and the competent authority to register and record. For the fields, industries, or projects on the negative list, the approval and administrative licensing system will continue to be implemented, and the industries that are prohibited for foreign investment and those that restrict foreign investment will be classified for approval and the approval only. Concentration review of foreign investment business operators. Now, the concentration review of foreign invested business operator means where a foreign investor acquires a Chinese domestic enterprise or participates in a concentration of undertaking in other ways. It shall accept the examination of concentration of undertaking in accordance with the provisions of the anti-monopoly law. Among that, concentration of undertakings refers to the following situation: merger of undertaking, acquisition of control over that undertakings by an undertaking by acquiring equities or assets, acquisition of control, or the possibility of exercising decisive influence or other undertakings, or by an undertaking by contract or by any other means. There are some situations that require special attention. If the concentration of undertaking meets one of the following standards, the undertaking shall report to the anti-monopoly law enforcement agency of the State Council in advance, and the concentration shall not be implemented if the declaration is not made. First, all undertaking participations in the concentration shall have global operations in the previous fiscal year. The total amount exceeds RMB 10 million, and at least two of the operators' turnover in China in the previous fiscal year both exceeds RMB 400 million. Second, the total turnover of all operators participating in the concentration in China in the previous fiscal year exceed RMB 2 billion, and the turnover of the last two of the operators in China in the previous fiscal year both exceeded RMB 400 million. After talking about the access and review system, let's see the legal application of different organizational reforms and organizational structures after the implementation of the foreign investment law. On one hand, the organizational form and organization of foreign investment enterprises shall be governed by company law and partnership law. On the other hand, regarding the connection between the new law and the old law is the application of laws on the organizational form and organizational structure of foreign invested enterprise. The foreign investment law stipulates a 5-year transition period. Of course, in addition to the promotion, protection, and management system of foreign investment, there are many other systems and regulations in this law, such as this Foreign Investment Information Reporting System and Foreign Investment Security Review System here. They also made regulation on other aspects of foreign investment. The Foreign Investment Information Reporting System refers to the establishment of a foreign investment information reporting system by the state. Foreign investors or foreign invested enterprises shall submit investment information to the competent Commerce Department through the Enterprise Registering System and the Enterprise Credit Information Publicity System. The content and scope of the foreign investment information shall be determined in accordance with the principle of necessity. Investment information that can be obtained through departmental information sharing shall no longer be required to be submitted. The Foreign Investment Security Review System refers to the establishment of a Foreign Investment Security Review System by the state to conduct security reviews on foreign investments that affect or may affect national security. The safety review decision made in accordance with the law is the final decision. Special note for this is, for the safety review decision made by the competent authority, its effect is the final decision, and there is no application for consideration or administrative legislation. The foreign investment law has undoubtedly sent a new round of signals for China's opening to the outside world and is of great significance to the future development of China's foreign investment. If you are interested in foreign investment law, you can also study its specific laws and regulations. This section ends here. Thank you for watching.